Hello, we've just opened the webinar for attendees to join, so we'll get started in just a couple of moments. Welcome. As you're joining, we will get started in a couple of minutes. I was a little later than usual opening the room because I was doing some last minute research that will be relevant to today's presentation that I will talk about as we get started. If you're joining, you should have the cover slide for today's presentation. What does OSHA's COVID-19 ETS mean for New York employers on your screen? You should have access to a chat window where you'll be able to ask questions during the presentation, and you should be able to hear me. If you have all those things working, then you're in good shape. So welcome as you are joining. We will be getting started in a minute or two. I just need to give a little extra time for everyone to get logged in since we were a little late starting or launching the room. I am Scott Horton. I will be presenting today's webinar on the OSHA COVID-19 Emergency Temporary Standard. As soon as we have given everyone a chance to get logged in, I will get started with the presentation. In the meantime, make sure you have access to the chat window so you can enter questions if you have them regarding the presentation. You should be able to see the cover slide for the presentation on your screen, and you can hear my voice, or else it doesn't matter what I'm saying. If all those things are working for you, then just hang tight and we will get started very soon. All right, I'm going to say one more minute. We will start the presentation. As we are waiting to give everyone the last chance to get logged in, I'll just mention that if you have any technical difficulties, try logging out and signing back in to the webinar. If you are having any trouble or there's lagging, then you may want to see if you can close other applications on your device to free up some resources. Otherwise, everything should be working from our end, and we generally don't have problems, but there are occasionally some things going on attendees' devices that we can't really fix during the presentation. That being said, the slides will be made available at the end of the presentation. So for those wondering, you will have access to that. You will also get an email tomorrow if you're registered that will have a link to the slides. So if you can't quite wait around until the end to get that link today, you will get that information by follow-up email as long as you are registered. And with that, I'm going to go ahead and kick things off. Again, my name is Scott Horton. I'm an attorney and the founder of Horton Law PLLC based in Orchard Park, New York, just outside of Buffalo. Today's presentation is on OSHA's COVID-19 Emergency Temporary Standard, most specifically targeted toward New York employers. We'll talk about which New York employers are covered by the ETS. We'll talk in slightly less detail about coverage in other states. Just so you know, if for some reason you have very few or no employees in New York, but are just generally interested in the information on the COVID vaccine rule, that will the overwhelming majority of today's webinar will apply outside of New York as well. But some of the particular interactions of state and federal law that I will comment on will be limited to New York law primarily, because it wouldn't be possible to address relevant COVID provisions in each of the 50 states and various localities within them. With that, let's move ahead. Let me mention some of the questions that we're hoping to address in this webinar. I can't guarantee that we're going to completely answer all of them for reasons mostly beyond anyone's control. First of all, will this even happen? The reason I opened this room a little late is I was still trying to get the very latest word on where the litigation stands over whether the OSHA rule, the vaccine mandate rule, will actually take effect. So I can tell you the status as of 4 or 5 minutes ago. And I doubt anything is going to change in the next hour during this presentation, but if it did, I would let you know. Assuming I can click on a couple of things at some point during the presentation and get an update. The big important question for everyone at the beginning of this should be whether your organization is even covered by the OSHA standard if it does take effect, and whether there are parts of your organization that are covered and others that may not be for various reasons, and then which employees are covered and which may not be for various reasons. We will discuss that. There is, under the OSHA emergency temporary standard that we're discussing, frankly, alternatives of either doing a full mandate requiring everyone to be vaccinated in order to report to work, or to allow a weekly testing alternative. And we will address some of the considerations in deciding which of those approaches to take. How do the paid leave provisions work? And this is one aspect of the OSHA rule that I'm going to comment on from a New York specific perspective, because there are New York legal requirements that will still apply, notwithstanding the OSHA rule if it takes effect. And that makes some of the issues under the OSHA rule less novel in New York than they might be in other places. And also regarding New York, what does this mean if the OSHA ETS takes effect for the New York HERO Act? Really two different questions there, because there's two different components of the HERO Act, one being the Airborne Infectious Disease Exposure Prevention Plan requirement, and the other being the Workplace Safety Committee provisions. And we will address both of those and how they may interact with the ETS. So these are just some of the questions I'm going to be discussing throughout the presentation. You can also ask your own questions, type them in the chat. I suggest you do it as you have the questions so you don't forget or run out of time to enter the questions. That being said, I can't guarantee that I will address all the questions as they come up. For the most part, I will save them to the end and have a question and answer session at that point. Keep in mind that if you ask a question, I'm going to likely read it and repeat it and answer it to the best of my general ability. If it's a very peculiar question that would relate only to your organization, you may want to avoid asking it here, primarily because we won't have any attorney-client privilege in that discussion. So if you want to keep it confidential, we can address it otherwise, or speak to your other labor counsel if it's not me. But if it's a general question and you're comfortable asking it, then I will stay on to answer it at the end of the presentation. We're aimed for an hour for the presentation, but if questions last longer, I will stay on to answer them all to the extent that I can. So first of all, big picture, what are we talking about? Well, we are talking about a specific emergency temporary standard that has now been put out by OSHA, the Occupational Safety and Health Administration. Per OSHA, this is within their powers under the Occupational Safety and Health Act. Many people disagree about that. Let me walk you through the timeline that we are faced with. On September 9th, President Biden made a broad announcement on various vaccine mandates, including one that he said would apply to employers with 100 or more employees. That is the OSHA ETS that we are discussing primarily today. At the same time, President Biden announced an executive order to impose a vaccine mandate on federal contractors and effort to impose vaccine mandates on healthcare providers. We will go into just a little bit more detail on those other mandates, primarily to describe how they impact the OSHA rule. So, after the president made the announcement of these vaccine mandates, including the rule for 100 employers with 100 plus employees, OSHA was tasked with creating such a requirement that would apply to employers with 100 or more employees. OSHA submitted its proposed rule to the White House Office of Management and Budget on October 12th. That was eventually approved, and OSHA released the text of this rule on November 4th. The next day, they formally published the rule in the Federal Register, technically making it effective then, although separate provisions said that there were no obligations on employers until later. Very quickly, literally the next day, on Saturday, November 6th, the Fifth Circuit Court of Appeals, which was just one of many federal appeals courts that had a case filed with it challenging the OSHA rule, issued a temporary stay of enforcement on the rule. By the following Friday, November 12th, the Fifth Circuit Court of Appeals had heard arguments from the parties, including OSHA, and again issued a ruling upholding the stay of enforcement. So this gets kind of interesting, depending on your perspective, maybe something different than interesting. But because there were challenges to the OSHA rule filed all across the country, there is a process for the federal courts to literally hold a lottery to determine which of the 12 circuit courts of appeals will hear all of these cases in a consolidated fashion. So the Fifth Circuit was within its rights to act when it did, but earlier today, OSHA filed its petition seeking this multi-circuit lottery, which is expected to happen today. And that's what I was just checking on right up to the time that we started this presentation to see where that stood. Again, we do expect the lottery to happen as early as today. By lottery, the process literally entails balls in a hopper being turned and a ball coming out, indicating which of the 12 federal circuit courts of appeals will rule on whether or not the OSHA ETS vaccine mandate will be enforceable. For a little bit more of a wrinkle on this, the Fifth Circuit was almost certainly the most likely circuit to block the rule. It is a very conservative circuit based in Texas. So there was no surprise that employer interest would go there to seek a ruling. The multi-circuit lottery only includes circuits where a challenge to the rule had been filed. But what is kind of a peculiar piece of all of this is that there are certain pro rule groups that challenged the rule intentionally in other circuits that would be deemed more likely to uphold the rule. So even though they probably ostensibly were in favor of the rule, they filed challenges to the rule in these other circuits for the purpose of having those more favorable circuits included in the lottery to increase the possibility of having the rule decided by a court that would uphold it. So that is where we sit. As early as today, we will know what circuit will hear the cases, and that will give us some better guess as to what they're likely to decide. No guarantees. If it stays in the Fifth Circuit, for example, it's pretty clear the Fifth Circuit is not going to allow the rule to take effect. The opinion of the Fifth Circuit Chief Judge was very adamantly opposed, both legally and frankly politically, to the concept of this OSHA rule. In the meantime, OSHA has said that while it remains confident in its authority to protect the workers in emergencies, it has suspended activities related to the implementation and enforcement of the ETS pending future developments in the litigation. You can go to their website on the rule, and that statement is there. Likely will stay there unless and until the stay is lifted. That doesn't mean that OSHA is not fighting to have the rule enforced. It just means that it's not legally able to take any actions on the rule itself or to encourage or require employers to comply until the court let it. The interesting thing about this multi-jurisdictional lottery that's going to take place is it's not really clear what happens next once the circuit is selected. So if it moves from the Fifth Circuit, it's possible that the new circuit would immediately lift the Fifth Circuit stay. It's probably more likely that they will schedule some arguments from some of the parties before they take action on the stay. But regardless of whether the stay remains in effect or not, they will issue a more permanent ruling at some point in time. And there is the likelihood that no matter what, whichever circuit gets the case or cases will rule, it will end up before the U.S. Supreme Court. Now, based on everything we know about the current makeup of the Supreme Court, based on what we know about the OSHA rule, based on what we have read in the Fifth Circuit's opinion, etc., my view is it's fairly unlikely that this OSHA rule is ever going to be enforced. Separate and apart from a lot of other political factors, the OSHA's track record on enforcing emergency temporary standards is not very good with the courts. They have to show a grave danger requiring this immediate action, and there are plenty of other issues to be considered in this litigation that I'm not going to get too deeply into, but I think it is fairly unlikely that the Supreme Court at least would allow this OSHA rule to apply and actually take effect. Unfortunately, that's no guarantee, and we have no idea what's going to happen between now and the time that the Supreme Court rules one way or the other, which could range from deciding not to issue a decision on the case at all to saying yes or no on the validity of the OSHA rule. If it takes effect as scheduled or roughly within the time frame as currently scheduled, then employers need to be prepared to take prompt action. So, are you an employer that may need to take prompt action on OSHA's emergency temporary standard? First of all, do you have 100 or more employees? All current direct employees count regardless of hours, compensation, etc. In other words, full-time employees count just the same as part-time employees. There's no calculation of full-time equivalents, etc. How many people are employed by the employer? Couple notes there. Employer can get a little bit complicated if there are multiple legal entities that might have separate payrolls involved. It is possible they would be lumped together as a single employer for this coverage requirement. In this case, that would primarily depend on whether there is centralized control and direction of safety and health issues. So if you sort of have a centralized human resources department that's going to oversee this for a couple of companies that are owned by the same owners or similar ownership groups with overlap, and they sort of funnel to the same, and you're going to apply generally the same safety and health and human resources types of policies to all those employees, then OSHA may say that you should count those employees collectively, notwithstanding separate payrolls. The other thing that OSHA has said is that if there are temporary staffing agency employees involved, then they only count for the number of employees of the staffing agency, not the workplace in which employees may actually be placed to work. So if you have 90 employees in your facility that are direct on your payroll and another 15 employees who are working there on the payroll of a staffing agency, you only have 90 employees and are not a covered employer under the OSHA standard, even though you might be deemed a joint employer of those employees for other purposes, such as discrimination laws. On the other hand, if the staffing agency as a whole has over 100 employees, then those 10 employees working at your facility are working for a covered employer and the staffing agency, and then you become jointly responsible for ensuring that in their workplace they are in compliance with the OSHA standard. So theoretically, you could have temporary staffing agency employees who are subject to the vaccine mandate while your 90 direct employees are not. The OSHA guidance takes a relatively simplified view on determining coverage in the sense that there's no real look back period or number of days or weeks of payroll that someone has to be employed or what have you. If at any point when the rule is in effect, you have had 100 or more employees, then from that day forward, as long as the rule remains in effect, you remain subject to the rule, even if your employee count then goes back under 100. So, in other words, if you have seasonal employment, especially coming up here at the holidays, if the rule's in effect and you go over 100 employees, but then drop back down even to a number that might be much less than 100 employees, you will still remain subject to the rule for all of your remaining employees as long as the rule is in effect. Technically, the rule took effect on November 5th, was then stayed on November 6th, and has remained stayed to this point in time, subject to further court action. Arguably, if you had 100 employees on November 5th, then you will be considered a covered employer at any point now when the rule takes effect, even though there's no other requirements under the rule that have yet become effective. That might be debatable. Obviously, the rule wasn't written with the expectation that it was going to immediately be stayed. But if you are in a situation where you're near that 100 employee threshold and have gone up or down since November 5th, then you may want to more carefully analyze that question and speak with an attorney about your potential coverage if and when the rule is enforced. There are a couple exceptions to that 100 employee threshold. First of all, any employers that are subject to OSHA's healthcare COVID-19 emergency temporary standard, which came out back in June, I believe it was, you are not also subject to this new vaccine mandate, ETS. The key point to note there is the healthcare COVID-19 ETS did not have a vaccine mandate, perhaps surprisingly, but there are other mandates, such as in New York State, for healthcare workers to be vaccinated. Those still apply. It's kind of complicated actually to determine whether you are subject to the healthcare ETS, even if you know you're in the healthcare space. Hopefully, because that rule came out several months ago, you figured that out if you're in that situation. But obviously, if you're not involved in healthcare, then you're not subject to that ETS. There's also a new federal vaccine mandate related to healthcare employers who receive Medicare and Medicaid funds that would require a vaccine mandate different from what the OSHA mandate will be. You may be subject to that. But the bottom line is you can't be subject to both of OSHA's ETSs, at least with respect to the same employees. You could be a healthcare entity that has some workplaces where employees are subject to the COVID-19 healthcare ETS, and others that are not. Those that are not may be subject to the OSHA general ETS for employers of 100 plus employees. Similar analysis could apply for federal contractors. By executive order, the president had the authority to require federal contractors to have a vaccine mandate. Where that applies, there is no testing opt-out, so it's different from the OSHA ETS in that respect. Go into a little bit more detail on that vaccine mandate in just a moment. The last key carve out could be for government entities, so state and local governmental employers, depending on which state you're in. Even if you have 100 employees, you may or may not be covered by the OSHA rule. It's kind of complicated, but certain states, including New York, have an agreement with the federal OSHA agency to apply standards at least as restrictive as the federal OSHA standards to public sector workplaces. So in New York, for example, we expect if the OSHA rule takes effect, it will apply to public employers with 100 or more employees, but it is possible that the state would then implement a more restrictive, in a sense, vaccine mandate on its public employers. That's possible, although the timing makes it somewhat unlikely. But that is something we're going to have to wait to see what happens. We haven't heard anything from the state Department of Labor yet on how it intends to handle that situation. And of course, it's complicated right now by the fact that the OSHA rule itself is technically under a stay. Fairly quickly on the federal contractors, The president's executive order applies to most federal contractors, including subcontractors. The cutoff becomes when you're a subcontractor. I think that only selling products and not performing services under federal contracts. If you have federal grants, grants are not enough to bring you within the coverage. The obligation on federal contractors is triggered by now new or recent contracts, including extensions, renewals, and exercises of options in the past weeks or months, depending on what the federal agency you contract with has put into their contracts. So you actually need to check the contracts, or if you're a subcontractor, ideally know what the contracts you're ultimately working under say, because there should be language in the contracts now that tell you that you are subject to the federal contractor vaccine mandate. As I mentioned, there's no test out option there. Covered employees working in covered workplaces have to be vaccinated, except for cases of accommodation of medical or religious beliefs. And the other key point here is it is possible for federal contractors to have workers in certain settings who are not subject to the federal contractor mandate. If, for example, they're working in workplaces that don't perform any work on the federal contracts, and therefore it's possible that that employer would be subject, with respect to some employees, to the federal contractor vaccine mandate, and with other employees to the OSHA mandate. The original deadline for compliance with the vaccine mandate for federal contractors was delayed to January 4th, which is intended to match the deadline for vaccination under the OSHA ETS. What exactly is going to happen with those deadlines again could depend on what is going on with the litigation. So next, we need to talk about which employees within covered employers are subject to the rule. It applies to all employees of covered employers, except those who don't work at a workplace where other individuals are present, which could include working from home, but could also mean you're actually going into work and you are the only one in the office or facility for whatever reason. Note that that is not limited to other employees. It would also include customers. So if you are the only employee scheduled to work in a retail store, for example, then assuming there are customers who are coming into the store and with whom you would interact, you do not count as being excluded under that basis. Working from home is an exception. If you only work from home, you're not a covered employee under this requirement, under the ETS. Of course, technically, you could work from home and other people could be present, primarily your family, for example, but regardless, working from home itself is specifically a carve out. And there's an exclusion for employees who work exclusively outdoors. This means primarily something like a landscape crew or construction crew that works only outside, although be careful in the construction context if they're building homes or buildings that will become enclosed structures. At some point, the structure is sufficiently completed that if the employee is standing inside the walls, they are no longer considered to be working outdoors. There is a minor caveat on the exclusively wording. If you have an employee who works outside all day and they have access to a company restroom and they come in a couple times a day to use the restroom, that doesn't change the fact that they work exclusively outdoors. Basically, when they're coming into the restroom, they're no longer working. All right. So, when do these requirements take effect? Well, right now, as long as the stay remains in place, they don't take effect. But assuming for these purposes, the stay were to be lifted before these dates, the rule itself would require compliance with all of the emergency temporary standard provisions except for weekly testing for unvaccinated employees by December 6, 2021. It's a little complicated to think about what that means. That's technically the way it's written. In effect, there's no vaccine mandate in place until January 4th, 2022, which is the full implementation deadline. Because even if someone is unvaccinated before then, they don't have to test until after January 4th. But there are distinctions to be made between vaccinated and unvaccinated employees between December 6th and January 4th, assuming this were to take effect. And notwithstanding the concept of the vaccination component not taking effect until January 4th, there is actually a lot that employers would have to do to be in compliance by December 6th. A quick note on that date, the date calculated as 30 days from the filing of the rule is technically when the the rule took effect or would take effect. 30 days from November 5th was December 5th. So you'll see a lot of publications mentioning a December 5th effective date. December 5th is a Sunday, and there's a separate administrative law provision that says that when the compliance date would be a Sunday, it moves to Monday. So most certainly the actual date is December 6th, the Monday. But again, what happens on December 6th will depend on what happens in the court between now and then. So before we talk about the big headline vaccine mandate, I want to go through the other administrative requirements placed upon covered employers. First of all covered employers, again, potentially as early as December 6th, must establish and maintain a roster of all of their covered employees' vaccination status and supporting documentation. So if you have 100 employees, you need some listing of all 100 employees saying whether or not they're vaccinated or if they've only received one dose and not two of a two-dose vaccination regimen. You need that information and the supporting documentation to show if they are vaccinated, which we'll talk about a little bit more. By that first effective date, covered employers also have to adopt a written policy, which seems to mean that by then you need to know whether you are requiring all employees to be vaccinated or allowing the weekly testing alternative. There's again no obligation to actually enforce that until later, but your policy has to be in place by December 6th. So it seems like you would need to know what the policy is going to say by then. I suppose there's um, nothing under the rule stopping you from changing your policy after December 6th. As long as you put it in place by December 6th, you could amend it or modify it, I suppose. But you can see the sense of urgency, especially with Thanksgiving coming up next week, to act on this rule, notwithstanding the fact that it's not currently in effect and frankly is probably more likely than not to never take effect. Covered employers, regardless of whether they apply the full vaccine mandate or allow the testing option, have to exclude employees who test positive for the applicable isolation period. Under the OSHA ETS, employees themselves have the obligation to report to the employer if they have tested positive. And this includes not only those unvaccinated employees who are going to have to test weekly eventually, but any vaccinated employees as well who test positive. And again, this is set to take effect on the earlier December 6th deadline, even before weekly testing would be required. If for whatever reason someone tests positive, the employer then has an obligation to keep them out of work during whatever the applicable isolation period is under CDC guidelines. The other caveat is the OSHA rule does specifically say if a doctor provides recommendation that the person is okay to return to work, then they can be allowed to do so. So I don't know too many situations where a doctor would be able to suggest someone should come back to work, notwithstanding a positive test, if they haven't followed the prescribed waiting periods. But that is theoretically allowed under the rule. Another requirement that will be imposed on employees under this rule, under employers under this rule, would be to report both COVID-19 related hospitalizations and fatalities to OSHA. So if someone contracts COVID-19 in the workplace and ends up needing an inpatient stay at a hospital, the employer must report that to OSHA within 8 days of learning of those circumstances. In the case of a fatality related to workplace incident of COVID-19 exposure, that has to be reported to OSHA within 24 hours of the employer getting that knowledge. Granted, there are plenty of questions to be had on how do you know whether it was work related or not. And, I suggest if you get into that situation, you analyze that in more detail, perhaps with your attorney. But for purposes of this presentation, just know that that is a requirement you have to be cognizant of so OSHA can find out where there might be workplace incidents and then, I suppose, swoop in. Going back to the requirement to get documentation of employees' vaccination status, this is the list of permissible documentation that employers can rely on. So it looks somewhat redundant, but this is the specific list they provide in the rule. The immunization record from a healthcare provider or pharmacy, the CDC's COVID-19 vaccination record card that most people who receive the vaccination are given, any medical records that document the vaccination, any immunization records from a public health, state, or tribal immunization information system, or other official documentation containing the type of vaccine, dates, and name of healthcare professional clinic site. So again, I think some of these overlap, but this is the listing from OSHA. There is also the fallback option of employee attestation. In other words, if the employee, for whatever reason, claims to be vaccinated but is unable to produce valid documentation, the OSHA rule does allow that they can sign something saying that they have been vaccinated. It must include an attestation that they are unable to produce other proof of vaccination. And it must include this very specific statement that is quoted here and is quoted in the rule, that includes the employee's acknowledgement that if they are providing false information, they may be subject to criminal penalties. So there's that fallback option. I don't know how many employees will get in a position where they genuinely were vaccinated and can't produce any of the forms of medical evidence that would be permissible under the previous listing. But if you get to this attestation, make sure you have the proper statements included, and the OSHA rules are pretty clear that if the employer is complicit in accepting an attestation that they know is fraudulent, then they also would be subject to criminal penalties, the employing entity, for example. All right. So here is the big money piece of the ETS. The Occupational Safety and Health Administration has, as the president suggested they should, allowed an alternative approach to a full vaccine mandate. You can adopt, and OSHA recommends and encourages adopting an across the board vaccine mandate with no test out require or yeah, with no testing option. The only thing you have to consider is possible disability and religious exceptions. OSHA does allow these. They don't say that you have to let somebody work despite not being vaccinated because of a religious or disability accommodation. They just note that you would be obligated to evaluate possible accommodations in certain circumstances under, for example, the Americans with Disabilities Act or Title VII with respect to sincerely held religious beliefs. But upon making that analysis, an employer subject to the OSHA rule can still say that, yes, we evaluated the accommodation, but we still don't think it is reasonable, or we think it would pose an undue hardship in our workplace to let you work in person without the vaccine. There's no clear guidance from the federal government as to what circumstances um, justify an employer telling someone they can or can't be accepted from the mandate. It's a case by case analysis that each employer would have to make, but you can make that exception and still be compliant with the OSHA vaccine mandate. The other alternative option for employers subject to the rule is to certainly get the information on vaccination status for all of your employees, as you'd be required to do. And then for anyone who remains unvaccinated, have them test weekly. The caveat on the effective dates is that that weekly testing takes effect or scheduled to take effect on January 4th, notwithstanding whatever the courts may say. But as of December 6th, the way the rule is written, any unvaccinated employees must, from that point forward, wear masks while they are in the workplace, with limited exceptions. The primary limited exceptions being if you're working outside or if you are in an enclosed office with the door shut and no one else is present. But any common areas or open areas, an unvaccinated employee must be wearing a face covering at all times beginning December 6th if this rule is in effect. Um, just a fairly quick comment on the question of whether you're going to have a vaccine mandate or a vaccine mandate subject to a test out and masking option. The National Labor Relations Board's General Counsel has announced her view that employers must bargain with unions over the ETS implementation decisions that affect terms and conditions of employment. What does that mean in English? If you have a union and you don't somehow have a pre-negotiated language with them that flat out says you get to decide whether or not to enforce a vaccine mandate, the new OSHA rules are going to require you to negotiate with the union over whether to have the full vaccine mandate or to allow the test out option. If the OSHA rule had just flat out says everyone is going to have a vaccine mandate with no testing option, then you wouldn't have to negotiate that with the union. It would just be an obligation of legal compliance. But because the law, and in this case, the OSHA rule, gives employers options, those options have to be negotiated if you have a union involved. Where the rule requires employers to take specific actions, the General Counsel further reminds employers of their obligation to engage in effects bargaining. In other words, uh, the rule requires something that we'll get to further about certain paid vacation time, not vacation time, paid leave time. And in that case, it might be the situation where a union would have the right to negotiate over what that's going to entail, what procedures have to be involved to take that, how much time gets paid, etc. That is the National Labor Relations Board, so that's private employers for the most part. If you're a public employer in New York, for example, you probably have those same obligations, but technically the National Labor Relations Board wouldn't have anything to say about it. It would be governed by PERB in New York. Testing requirements, if you allow that option, unvaccinated employees cannot be in the workplace unless they have tested negative within the past 7 days. The OSHA wording is a little more complicated. If the employee regularly comes into work at least once a week, then they have to get tested every week, and then provide the results to their employer within 7 days of the last result to continue working in the workplace. If you go longer than 7 days without having been in the workplace, then you don't have to test while you're, on vacation or working from home or something like that. But you have to produce a negative test from within the past 7 days, upon returning to the workplace. So, again, in essence, it basically boils down to you can't be in the workplace as an employee who's unvaccinated unless you have proof of a negative test within the past 7 days. OSHA doesn't require employers to pay for testing, but other legal obligations may apply. This may be something that has to be negotiated with unions if there isn't already a provision in your collective bargaining agreement that might somehow apply. Under New York law, it's arguable that requiring employees to get a medical exam, which could include this testing, has to be paid by the employer, but there is a carve out to that language for situations that are required by law. There's some ambiguity and potential room for argument as to whether that exception will apply in this situation for various rules, for various reasons. I can't really comment on that because I think different employers are going to reach different decisions, and it may depend on factors yet to be determined with the courts. But if you're in a situation where you have to determine whether you're going to pay for testing, again, you may very well want to review that with counsel for your situation specifically. There are a wide range of accepted tests and testing procedures. The primary carve out is that you cannot have testing that the employees perform themselves and report to you. In other words, someone can't do an at home test and just tell you, oh, I was negative. They can technically do an at home test sitting in the office in front of, a human resource person or a nurse that works for the company or something like that. In that case, it's self administered, but not self reported because there's someone else there for the company to witness the outcome of the test. Probably in most cases, employers are going to expect some sort of medical provider to perform the test, but there are a range of options available under the rule. So regardless of whether you're requiring the mandate absolutely or you're allowing the test out option, another requirement from the OSHA ETS is paid leave, both for vaccination itself and for recovery from the side effects of vaccination, although the parameters vary a little bit between the two. Regarding vaccination, you have to pay employees for up to 4 hours of time, including travel time, per dose. So if they get a 2-dose vaccination, then it could be up to 8 hours. It's a reasonable amount of time of up to 4 hours. So if there's a clinic across the street and someone can walk over in 15 minutes and walk back, they don't have to be paid for 4 hours just because. But if reasonably takes up to 4 hours, they're entitled to 4 hours. This clearly applies only to the primary vaccination sequence, not to any booster shots that someone may choose to receive. This is already required under New York law. So if you are a New York employer or focused on employees within New York, this doesn't really change anything, but it is a component of the OSHA ETS. The thing that's not provided in New York now is paid sick leave to cover side effects of the vaccination. The OSHA commentary on its rules says that up to 2 days will generally be considered reasonable and that you probably don't have to provide more than that. However, that 2-day number is not hard fixed in the rule. It says reasonable. So there might be some circumstance for some reason that someone might have an argument that more than 2 days is reasonable. But there is guidance from OSHA that says generally 2 days is enough. I said New York doesn't require that. That is specifically true, although because OSHA says you can count existing paid sick time or PTO time to meet this requirement, and New York does have a paid sick time requirement, at least for all employers with 100 or more employees in New York. I guess you could look at it as to say, well, this is kind of already covered in New York. But the caveat to that is under the OSHA rule, even if someone has sick time available to them, generally, if at the point in time they need time off to recover from the side effects of the vaccination, they have already used up their sick time, you still have to pay them for a reasonable amount of time, which OSHA says is up to 2 days. So the fact that they have already used their time doesn't prevent them from being paid for the time. But if they still have the time available, you can make them use it. But it has to be time designed to cover sick leave. So either sick leave or an omnibus paid time off. You can't require them to use vacation time that is ostensibly intended for another purpose to meet this requirement. All right, a couple final requirements, just so you have it. The covered employers have to provide to all employees in a language and at a literacy level the employee understands, which I'm not really even sure how that's plausible, because almost no one who could read these OSHA rules could understand them in themselves. But somehow you have to do that. But clearly, the language requirement means if you have employees who don't speak English, you're going to need to provide it in a different language. You have to provide the following: some information regarding the ETS requirements and the related employer policies and procedures. Specifically, the CDC document, key things to know about COVID-19 vaccines. Although the OSHA refers to it as a document, it's basically a web page that has a lot of information and scrolls on and on. I don't think there's a specific PDF version of it readily available, but I guess somehow you're going to have to figure out what it means to provide that document. For now, I guess you print out the web page unless OSHA and CDC get together and decide a different format for that. You have to provide OSHA rules that prohibit employers from discharging or in any manner discriminating against an employee for reporting a work-related injury or illness and for exercising rights under the ETS, and information on federal laws providing for criminal penalties associated with knowingly supplying false statements or documentation. Uh, Obviously, this relates to the vaccination documentation. What most employers are probably going to do is combine all of these required pieces of information into their policy or policy with exhibits or whatever it might be. To that end, OSHA has posted sample policies on its website, osha.gov/coronavirus/ETS2. Notably ETS2, presumably because ETS1 was the healthcare ETS issued earlier this year. But regardless, there are separate sample policies for whether you're going to do a vaccine mandate or the mandate subject to the weekly testing alternative. Whichever of those approaches you're going to choose, I think you're going to need to substantially revise the sample policies OSHA has available. They are not ready to go policies. They are just really a starting point for most employers, especially because you might have to factor in separate legal requirements in your specific state on such things as paying for testing or whatever your union obligations currently are. And some employers are going to have to deal with complexities of having certain employees who are subject to some requirements, whether because they work on federal contracts or they're working in a healthcare setting, and other employees who are not, and possibly distinctions between employees who work on site and work from home, etc. Of course, always good to tell you what happens if you need to comply and don't. The current OSHA penalties allow for up to $13,653 penalty per violation and up to $136,532 per offense for repeated and willful violations. There's actually proposed legislation in Congress right now that could increase OSHA's penalties to 10 times those amounts. Because it's applied per violation and because OSHA has discretion up to those amounts, it's hard to know exactly how much you would have to pay if you violate certain provisions of the OSHA ETS if it ends up applying to you. But needless to say, nobody wants to pay tens or hundreds of thousands of dollars due to OSHA violations if you can avoid it by complying. Finally, I mentioned New York employers need to understand a couple of things related to the HERO Act, which you've probably been already trying to figure out for the past few months. Airborne infectious disease exposure prevention plans had to go in effect back in September around Labor Day. And as of the last extension by the Commissioner of Health, must remain in effect through at least December 15th. I think it's quite likely that that would be extended beyond December 15th at this point. But here's the catch. It expressly doesn't apply to employers who are subject to OSHA's regulations. So if you are currently complying by having your airborne infectious disease exposure prevention plan in place, if and when the OSHA ETS takes effect, you will technically no longer be subject to those requirements of the HERO Act and no longer need to keep your airborne infectious disease exposure prevention plan in place. And whatever the requirements you had with respect to that component of the New York HERO Act go away as long as you're subject to this OSHA rule, even in cases where that state requirement would have otherwise required you to do something more on a specific issue than the OSHA rules will. That is kind of like, well, we're probably going to be subject to one or the other, depending on what the federal courts do. Expect to keep the HERO Act plan in place until you know you are now subject to the federal OSHA rule. And the other wrinkle under the HERO Act is the second section of the HERO Act created this workplace safety committee requirement, which took effect on November 1st. Unfortunately, despite promising to do so before then, the Department of Labor has not yet, more than 2 weeks later, issued any guidance on how to comply with the workplace safety committee provisions. What we do know is that the Workplace Safety Committee requirement applies to private employers in New York with at least 10 employees. So, certainly, anybody who is subject to the OSHA ETS with 100 or more employees in New York is likely to also be subject to the Workplace Safety Committee provision. And that could become relevant because the OSHA rule requires you to have a policy, and the workplace safety committee law says that the safety committee has the right to review the adoption of any policy in the workplace in response to any health or safety law, ordinance, rule, regulation, executive order, or other related directive. So while in some workplaces, especially if there are unions involved, and diverse groups of employees who might have different interests in constituting the workplace safety committee, you might not yet have a workplace safety committee because you're hoping the Department of Labor will help tell you how to do that, and frankly, even what review of a policy means. But nonetheless, technically, that provision of law is in effect, and you are now potentially going to have to implement a policy that, if the OSHA rule becomes effective, is a law, ordinance, rule, regulation, executive order, or other related directive. Whether you want to argue over which of those it is probably becomes irrelevant. I think it's hard to argue that it's not one of those things or that it doesn't apply to health or safety. So again, I recommend discussing that with your attorney in your specific situation. Some of you probably already have workplace safety committees that are compliant with the law. In that case, I think you can take for now the position that review means here's our policy, look at it, feel free to tell us what you don't like about it, but the company is not necessarily obligated to do anything different. But if, again, it's hard to figure out how to even create your workplace safety committee, it's going to be hard to allow them to review the policy in the first place. And again, if you have unions, you might arguably have obligations to negotiate with the union and separately allow a separate workplace safety committee to review your policy. I know that is a lot of information, especially given that it's a lot of information about something that may never actually have the force of law, but it is something that could apply to all or many of you within the next couple of weeks. So unfortunately, we're all stuck between a rock and a hard place in figuring out what to do now, and all we can do is keep watching for every development to see what happens next. I'm, as we speak, refreshing something to see if there has been any designation on the circuit that will handle these cases. At this point, it doesn't appear that there is. So what I'm going to do in just a second is put up the link for the slides for today's presentation. Thanks to all of you who have stayed with us this far. I know we have some questions, so I'm going to move towards answering those. But to get the quickest information that we can get you, follow us on LinkedIn. If you're registered for this, you'll probably get our monthly email newsletter, and we might send out updates if they're pressing enough short of our monthly distribution. We try to keep that limited, but on LinkedIn, if you just follow Horton Law, you'll be able to get whatever we have to share as quickly as possible. If you have questions that you haven't typed in, go ahead and start doing that. I'm going to start preparing to answer the ones that are in. In the meantime, I'm going to make the link available to the slides. And then just give me a few seconds to get prepared to answer these questions. Okay, so the first question we have is, are we able to forego weekly testing if we require the vaccine? For example, can we terminate employees if they decline to get vaccinated? And so, assuming, um, let's assume the OSHA rule takes effect and we're talking about that situation, although probably the answer is about the same either way. If you want to, you can adopt a vaccine mandate. You don't have to allow the test out option. You can say everyone has to get vaccinated. The OSHA rule allows you to make an exception for someone who has a medical reason that they can't get the vaccination, and for any disability accommodations or religious accommodations that may be necessary to comply with the anti-discrimination laws. OSHA does not say that just because somebody asks for an exception, you have to grant it to them, even if they have a religious reason or a disability reason. They just say you can, but you are still subject to those laws. So you need to at least evaluate the accommodation request, decide whether there is a reasonable accommodation that will still allow them to perform the essential functions of the job or not, and then make the decision whether that means you're going to terminate their employment. There may be possible exceptions to immediate termination. It could include unpaid leave, for example, could include working from home, but there's no um, absolute answer across the board as to what you can do or can't do in those situations. Unfortunately, all of them would be determined on a case by case basis as to whether there's an accommodation that's actually needed in the first place, whether there's one that's reasonable, whether the only reasonable accommodation is not having to be vaccinated and still permitted to work. Possible accommodation would be to allow someone to test weekly and wear a mask. But again, the law doesn't absolutely require that. Unfortunately, you just get into a huge gray area. But as a general matter, yes, you can say just everyone has to vaccinate subject to those accommodation issues. If you just have no religious or disability reason to not get vaccinated and you don't get vaccinated, there's no obvious prohibition on then terminating that person's employment. Not to say someone won't come up with some sort of creative claim. There's going to be a lot of litigation over those sorts of things, but that's basically what the law suggests and what this rule suggests at this point. All right, let's see. Does the 100 employee threshold include employees in a parent company when the parent company owns 100% of its subsidiary? There would technically need to be more detailed analysis of that, but likely, yes, that would all count as one employer. Again, the key distinction for OSHA purposes is whether there's centralized control and oversight of the health and safety function. So if, for example, there was an employee who legitimately had its own human resources or health and safety department and managers and policies that were developed independent of the parent company, then there might be a wall between the two and you wouldn't have to lump the employees together. But that's typically not the case in those types of organizations unless they're both comparatively large. And again, if you're talking about a subsidiary with less than 100 employees of its own, there's a likely chance that there is a combination of those functions between the parent and the subsidiary, but you would have to address that in more detail. Do you count employees working overseas for the 100 employee threshold? My recollection is that OSHA was clear that it's only US employees. Yes. I just checked my notes. All US employees would have to be counted, even if you only had, for example, two in each state. It doesn't matter that they're spread out, but they do have to be in the United States. That could still raise some questions. What about employees who live in Canada and technically report to an office in New York State, for example, or someone who spends a portion of their year in one country, another portion of their year focused and located in the United States? Those issues might require more analysis, but the basic answer from OSHA is you're looking at US employees. Should the reporting to OSHA for work-related COVID-19 inpatient hospitalizations be done regardless of size of employer, i.e., if you're under 100 employees? Well, this rule specifically requires it for the employers subject to this rule, which is only employers uh, with 100 or more employees. So the question is, are there general OSHA reporting requirements that would have to be reported? I'm actually I'm trying to double check as we are looking. So there are requirements for employers, many employers with 10 or more employees to keep a record of serious work-related injuries and illnesses. They may then have direct reporting obligations. So yes, I think ultimately the answer to the question is yes, it is possible that even if you have under 100 employees, you under existing general non-COVID specific requirements would need to report those types of incidents to OSHA. But the other question on that is what determines that COVID-19 was work related? Well, that is a tough question for sure. One that is starting to be litigated and will continue to be litigated. It's going to probably be an issue of if it's a close call, again, talk to your attorney and analyze it in your specific circumstances to weigh the different factors as to whether you feel you have a reporting obligation. Doesn't necessarily have to be a attorney if you are a large enough organization that has experienced safety compliance officer or something like that as well. They may be able to make that decision, but again, it's not an easy question to answer. I think what OSHA most obviously has in mind is a situation where it's easy enough to trace the person's contact and exposure to COVID to another employee in the workplace. And with contact tracing being a reality and stuff like that, there might be evidence of that having been the case. But of course, it's always possible that someone contracted COVID from outside the workplace. I think, especially in the case of a fatality or a serious hospitalization, most employers are going to be better off reporting it and then trying to argue that it wasn't actually work related after the fact than to risk someone dying, somehow OSHA becoming interested that it might have been a work related fatality and then charging the company with not having reported it. You don't have to report it in a way that concedes that it was a work related fatality. You can let OSHA know that someone was hospitalized or passed away from COVID, and it's possible that there was workplace exposure. But again, consult with experts perhaps before doing that to position yourself as well as possible. If you're subject to the OSHA healthcare ETS, can you disregard the New York HERO Act requirements? Yes and no. So let's be real clear, the New York HERO Act has two sections. The first section all relates to the Airborne Infectious Disease Exposure Prevention Plan. The second section is the Workplace Safety Committee. The Workplace Safety Committee provisions don't have any sort of OSHA related carve outs. So there's no obvious reason to believe that being subject to any OSHA ETS has anything to do with your obligations under the Workplace Safety Committee provisions of the HERO Act. On the other hand, to the extent you're talking about the OSHA healthcare ETS vis-a-vis the Airborne Infectious Disease Exposure Prevention Plan, then yes, to the extent your workplaces are subject to that OSHA rule, or if they become subject to the 100+ employee OSHA rule, then they are no longer subject to the Airborne Infectious Disease Exposure Prevention Plan requirements. Again, with the caveat that it is possible that you could have some workplaces subject to the OSHA healthcare ETS and others that are not. And if that's the reality, then those others that are not may currently still be subject to the Airborne Infectious Disease Exposure Prevention Plan requirements, and that might drop off if and when the OSHA 100+ employee threshold ETS takes effect. And the OSHA 100+ employee ETS could apply to aspects of your workplace not subject to the OSHA healthcare ETS, if any, even if you have less than 100 employees in those specific components of the organization, because it's 100 employees overall, not necessarily 100 employees who would be subject to the OSHA 100+ employee vaccine mandate ETS. So obviously there's some very complex issues of coverage in certain situations that, again, you'd want to be careful to review in case there's any risk that some portions of your operations could be subject to one set of requirements and another portion subject to another. We talked to the extent of any specific state law about New York here today. Obviously, many organizations have employees in multiple states, so that could only further complicate things. The OSHA rules are obviously federal and could apply nationwide, but there are nuances there depending on whether the state has a state OSHA plan, an agreement with OSHA, in which case OSHA may apply, but the state could make more restrictive or more employee protective parameters. There's the private and public distinction to be had, and that varies from state to state. Plus, every state has addressed OSHA differently. I mean, not OSHA, COVID-19 differently. So there may be remnant state laws that apply in some states that don't apply in other states. And there are even further complicated OSHA preemption issues that could arise, such as, do general state provisions related to COVID-19 in certain respects get preempted by the OSHA rule if it becomes applicable? And there's reason to believe that in some cases, state laws would be preempted by the OSHA standard. So unfortunately, there are still many unanswered questions and details that need to be worked out, potentially on a workplace by workplace, or even in some more limited cases, employee by employee basis, to determine what the different requirements are. If there are any more questions, go ahead and type something in now, even if you're just letting me know that you have another question. Otherwise, if I don't see anything new come in the next 15 seconds or so, I will probably just wrap this up. Thanks to all of you who have sat through this to this point. Hopefully it was good information, the best we can do on a law whose future is very uncertain, and implications, of course, could be immense if it does take effect. We are however many months now into a global pandemic that we've all been struggling to deal with from a compliance and operational and frankly just human perspectives. So, we just continue to do the best we can to address and tackle these new legal parameters as they come forward. Certainly, it's not making anybody's life much easier to do so, but um, it is what it is. All right, so I don't see any more questions. I'm going to go ahead and wrap up. Again, thank you all for attending. We will try to keep updated on whatever new developments there are regarding these issues and look forward to speaking with you again in the future.